Hi, everyone. Thank you for joining us today for the Epilepsy Foundation of Connecticut Winter Webinar Series. And today we have Cherie Sanders, MSW, and she is the manager paralegal with the Jeannie A. Carpenter Epilepsy Legal Defense Fund, and that is with our national office located in Maryland. She has been there for 11 years, and today she's going to be talking about legal advocacy, specifically for people with epilepsy and specific more to education and employment. So you are all, right now, you are in listen-only mode. If you have questions, please type them in the questions section that you see there on your screen. And we're going to have time for questions at the end of her presentation. And if there's any technical difficulties on your end where you're not hearing something, please type in that section as well. And this is being recorded, so you can pass that on to others, and also you'll have an opportunity to go back and listen again if you so choose. So I'm going to hand it over to Cherie now, and thank you.
Thank you, Monica, for the introduction, and I'd like to thank everyone who is participating today. Today's webinar is entitled Legal Rights and Advocacy Strategies for Employment and Education. For today's webinar, I will provide an overview of the Jeannie A. Carpenter Epilepsy Legal Defense Fund. I will provide an overview of employment laws that apply to employees with epilepsy, as well as education laws that affect students with epilepsy. I'll also discuss a few scenarios related to questions that the fund has received in the past and advocacy strategies. And I have also shared some employment and education resources that may be helpful for participants in the future. And then we will have time for some questions. So I would like to inform webinar participants and those listening to the recording that this presentation provides general information that does not represent a complete recitation of laws and policies. Nothing said during this presentation should be considered legal advice. So the Jeannie Carpenter Epilepsy Legal Defense Fund was launched in 2004 with the mission to protect and promote the civil rights of people with epilepsy. The goals of the Legal Defense Fund are to end epilepsy-related discrimination and injustice through education and increase access to legal services, and also to advance the rights of people with epilepsy by changing discriminatory practices, policies, and laws. The fund provides technical resources to consumers, our Epilepsy Foundation affiliates, and attorneys related to epilepsy-based discrimination. So this slide shows a list of the fund's priorities. Employment discrimination continues to be our highest priority because we get the most requests for information and assistance in this area. We also have listed here education, access to places of public accommodations, criminal justice issues, primarily where there have been arrest procedure-related behaviors, discrimination in housing, and insurance. And on this slide, there is a picture of Jeannie Carpenter. She was a passionate advocate for people with epilepsy, and she served as a volunteer leader with the foundation for several years. So our next slide shows ways that people can contact the Legal Defense Fund. So we have an online application that can be accessed through our website, and it's listed there. People can also reach us by telephone through the Foundation's 800 line and select option number 2 to reach us directly. And then I have listed our email address. So now we will get into an overview of relevant employment laws. So Title I of the Americans with Disabilities Act is the federal law that protects employees with disabilities. The ADA is designed to help people with disabilities have the same employment opportunities and benefits that are available to people without disabilities. In 2008, the ADA Amendments Act was signed into law, which amended the ADA to expand the definition of disability and to broaden coverage so that more people with disabilities could be protected by the law. In this slide, I have listed the 3 criteria that must be met in order for a person to be considered disabled under the ADA. One of the key elements of the ADA is the requirement for employers to provide reasonable accommodations in the workplace as long as these accommodations do not present a significant administrative and financial burden to the employer. A reasonable accommodation is a modification or an adjustment to a job or work environment that allows a person with a disability to perform the essential functions of his job. Examples of reasonable accommodations are a modified work schedule or allowing a person to take a break to recover from a seizure. Other features of the ADA include its limitations on questions that can be asked by employers about disability during the job application and interview process. A job applicant is not required to disclose that he has epilepsy or any other disability during the application or interview process. If a person voluntarily discloses, the employer can only ask follow-up questions if he believes the person will need an accommodation to perform the job. And those questions are, do you need an accommodation, and if so, what type of accommodation? An employer can ask medical questions after there's a conditional offer of employment. An example of this is where a person receives a job offer and a medical examination is required. In this case, the employer can ask about the person's health condition. But an employer cannot exclude a person from a job just because they have epilepsy. They have to do an individualized assessment of the person's medical condition and ability to perform the job duties despite health conditions. So another law that protects employees with disabilities is the Rehabilitation Act of 1973. This law forbids discrimination by federal agencies. So Section 501 of the Rehab Act protects federal employees. Section 503 prohibits discrimination by federal contractors and subcontractors in their employment practices. And Section 504 prohibits discrimination by programs and activities that receive federal funding. So states also have anti-discrimination laws that provide employment protections. The ADA covers employers that have 15 or more employees. Some states cover employers with less than 15 employees. For your state, the Connecticut Human Rights and Opportunities Act covers employers with at least 3 employees. So if a person works with a small employer or works for a smaller employer, the state law would likely be applicable. So we're going to talk about the Family Medical Leave Act, also known as FMLA. So FMLA allows employees job-protected time off from work for a serious medical condition. Employees can take up to 12 work weeks of unpaid leave during a 12-month period. This leave can be taken for the employee to deal with his or her medical condition or the serious medical condition of a family member, such as a spouse, a child, or a parent. A person with epilepsy might take this type of leave to deal with medication adjustments. And I've listed here the criteria for employers who must adhere to the Family Medical Leave Act. So on this next slide, it outlines which employees are eligible to use the Family Medical Leave Act. So there is criteria there, and I've listed it. I won't go over it, but you can read it on the slide. So Connecticut has a family medical leave provision, and some of the elements may differ from the federal FMLA. And I provided an example here on this slide. I've also provided a link on the resource web pages, on the resource slides at the end of this presentation that outlines the provisions of the of the federal FMLA and its comparison to Connecticut's FMLA. So we're going to move on to an overview of education laws that protect students with disabilities. The Individuals with Disabilities Education Act, also known as IDEA, requires schools to provide a free and appropriate public education to students with disabilities. This includes providing special education and related services to qualified students at no expense to the parent. And charter schools also have an obligation to students with disabilities under a provision of IDEA. A student may be entitled to special education and related services when his disability affects his educational performance. If a student is evaluated and found to need special education services, he will need an individualized education plan, also known as an IEP. And the IEP is basically a plan that is tailored to the unique educational needs of the student. Related services can also be part of the IEP. An example of a related service may be speech therapy, it may be some type of occupational therapy, psychological therapy, or school health services like medication administration. So Section 504 not only provides protections in employment, but also for students with disabilities in public, elementary, and secondary schools, private schools that receive federal funding, and colleges and universities. Students must meet the definition of a disability, meaning they must be substantially limited in one or more major life activities. They must have a record of the disability or impairment, and they must be perceived as having a disability or impairment. Section 504 also protects students with disabilities from being excluded from extracurricular activities. Grade school students with epilepsy may be eligible for a 504 plan instead of an IEP. A 504 plan may apply when the student's academic performance may not be so adversely affected that special education services are needed, but the student may still need reasonable accommodations because of their disability, like extra time to complete tests or assignments, or they may need help with medication administration. As it relates to the ADA, Title II applies to public schools. And there's also the ADA requirement that still applies here of a reasonable accommodation having to be provided as long as there's not a significant burden. Title II also applies to colleges and universities. It is important to note that there are some differences in the requirements of colleges and universities as it relates to accommodating students with disabilities, and I'll talk more about that when we go into our scenarios. Title III applies to places of public accommodations which are places of business or places that are open to the general public. And schools fall into this category because, of course, they have to be accessible to students with disabilities. And I also want to note that private schools that are not run by religious organizations are required to comply with the ADA. So now we're going to move into our scenarios. Scenario 1, I'm going to read it and then we'll talk about it. So it says, I can work, but I need reasonable accommodations so that my manager doesn't send me home after a seizure. How do I request a reasonable accommodation? So under this scenario, the person is being sent home from work, which would imply that there's an unnecessary use of leave and there's probably loss of pay. In order to request a reasonable accommodation, the employee can make a verbal or written request for a reasonable accommodation. I always recommend that the person do the request in writing for the purposes of maintaining documentation and also creating a paper trail in the form of a short letter or an email that is addressed to the human resource manager and the person's supervisor. The person can simply state that he is a person with a disability and that he is requesting a reasonable accommodation in accordance with Title I of the Americans with Disabilities Act. He can also list the type or types of accommodations that are being requested and how these accommodations will help him to continue to perform his job duties. The letter can also include a sentence or two about requesting a meeting to discuss the accommodation request, and the employee can also mention that he is open to any accommodation ideas that the employer may have, or discussing any accommodation ideas that the employer may have. In the letter, the person should give the employer a reasonable amount of time to respond, and I generally recommend maybe a deadline of 1 week. So after the employer receives the accommodation request letter, the employer is required to engage in an interactive process with the employee to determine an accommodation that is suitable for both the employee and the employer. The employer will probably request medical documentation to substantiate the need for a reasonable accommodation. And for this particular scenario, a good accommodation might be providing a rest area and allowing the employee to take a break after a seizure. And a reasonable time frame to ask for may be 20 to 30 minutes or whatever is recommended by the employee's doctor. Other accommodations employees with epilepsy may need are rubber matting around their specific work area to cushion a fall if they stand for a good portion of their job, or a consistent work schedule may be an option for those whose seizures may be provoked due to sleep deprivation. So the next scenario, I have always wanted to become a police officer, and I would like to attend the police academy. When I ask other people, they tell me I will not get hired, so I shouldn't bother. I'm wondering if you can explain to me if I can become a police officer. My seizures are well controlled with medication. So this is actually an email that I received email to the Legal Defense Fund. And I get this question often from individuals who are interested in first responder jobs. That's police, firefighter, type jobs. Now, these jobs are considered safety-sensitive jobs because there's a high amount of risk not only to the individual but to the public. When I get this question, I recommend that the individuals move forward with applying for the position if their seizures are well controlled, meaning they've been seizure-free for a significant amount of time, and if they have discussed it with their doctor and have their doctor's support. I think that's very important. For these types of jobs, the job offers are usually contingent upon completion of exams. Sometimes there's a written exam, physical exam, and it's definitely a medical exam. Regarding the medical exam, the employer's doctor should not exclude the job applicant from the position just because he has a history of seizures or epilepsy. The ADA requires individualized medical assessment of the person's health condition, and those medical assessments should be based on the most recent objective medical evidence. And so if a person finds that they are simply ruled out for a job and, the employee's doctor did not consider that they've had that type of job before and they did it without any problems, and then that's the point where they should probably seek legal consultation because it could be discrimination there. If they've had the job before and done it and had no problems, and the employer's doctor is not considering that in the decision on whether to rule them as fit for duty, then it may be a time to seek legal consultation. So we'll move on to some education scenarios. So the first one reads, my child has epilepsy. His condition is causing him to do poorly in school. I think he may need an IEP. What can I do? So if a parent feels that his or her child's learning is being adversely affected by epilepsy and the child may need special education services, the parent can write a letter to the school's principal or to the special education administrator to request an evaluation for special education. In the letter, the parent can state the reason why they're requesting an evaluation, and I recommend that they do a letter rather than make a verbal request because, again, they want to have a record of medical documentation, and they also should know that under the law there's a time when the evaluation should be completed. I believe IDEA requires 60 days for the completion of these evaluations, but some states may have shorter time limits. So once a parent makes the request, they should receive notification from the school about whether the school will or will not, whether the school will agree to complete the evaluation. If the school agrees, then the parent should receive notice about the assessment procedures, and a report should be completed by the professionals who do the assessment. Students may be assessed regarding academic performance. They may be assessed regarding communication skills, their health, motor skills, general intelligence, or social, emotional, and behavioral status. Once the evaluations are completed, an IEP team that includes the child's parents, special education teacher, a general education teacher, school nurse, school counselor, a social worker, a representative from the school district, and an evaluation expert who can evaluate the results of the student's assessments should gather together and discuss, what will be included in the child's IEP. If there's a dispute between the parents and the school about the IEP, then there should be an attempt to resolve the issue through mediation. If mediation fails, there will probably be a need for the parents to move forward with what's called a due process hearing. And if it gets to the point of mediation and needing a due process hearing, that is the point where I feel an attorney would need to be involved. And so the parents, would consult an attorney that specializes in handling special education issues. I also want to note that our parents can request the child be evaluated, but a school can also request it too, based upon a teacher's recommendation. But before any evaluation of a child can be done based on a teacher's recommendation, the school will have to seek consent of the parent. So we'll move on to scenario 2. My daughter will be graduating from high school this year and will be attending college. She has had a 504 plan throughout high school. Are any accommodations available for her on the college level? So, as I said before, accommodations on the collegiate level are different than those that are provided to elementary and secondary school students. Colleges and universities are required to make academic adjustments or provide auxiliary aids to support students with disabilities. However, there's a lot of responsibility on the student. So a college student must self-disclose his disability to the school through the Office of Student Disability Services, or whatever the name is designated for that office. And this office usually has a Title II Section 504 coordinator on staff that will work with the student regarding what type of accommodations are available and what documentation is needed to support, the existence of a disability covered by Section 504 or Title II of the ADA. And I recommend that, once a student is accepted into a college and he feels that he may need a reasonable accommodation, he should contact that office immediately. It's not good to wait until the student is in a class and he's not doing well and possibly failing to say, oh, I need an accommodation. A school can't provide the accommodation if they have no knowledge that the student has a disability. So some of the types of academic adjustments that may be available to students with epilepsy, college students with epilepsy, may be extra time for exams. It may be note takers. It may be that a student may request the ability to take their lectures. And there's, a list of other academic adjustments that are available to students with disabilities overall. And of course, they will have to meet, they will have to be applicable to a student with epilepsy. And I've shared a link in the resource pages about transitioning from high school to college and preparing students for post-secondary education. So that concludes the presentation. Here are the resources I've listed here. We have the Epilepsy Foundation website where we have epilepsy legal resources and general resources. I've put some resources regarding FMLA, the Connecticut Commission on Human Rights and Opportunities, which is the state agency that enforces your state's anti-discrimination laws. And then, of course, the EEOC, the Equal Employment Opportunity Commission, which enforces the Americans with Disabilities Act. And then the U.S. Department of Education fact sheet for students with disabilities in charter schools. And the fact sheet regarding preparing students with disabilities for post-secondary education. And so now I am open for questions.
If anyone has any questions, please feel free to type them in the question section. We'll give you a few seconds to do that if you have any questions. It could be anything related to this topic. Well, while we're waiting, if no one does have any questions, I do want to thank Cherie for her presentation. And really, our hope with this webinar was to really empower people with information, particularly empower them with what their rights are in these two scenarios and in general, and to know where to go to ask the right questions and to get the right information, so that you're not treated unfairly. So. I guess, it looks like we do have a question. Okay. So, Cherie, this says, I work in an epilepsy clinic, and many of our patients report applying for one job after another and being rejected as soon as they disclose their epilepsy in the interview. And so they're asking, is it better for them to wait to disclose their epilepsy until after they are hired? That's the question.
I would say yes. I don't believe that there's a need to disclose, and they're not required to disclose unless they need a reasonable accommodation during the application process. So if they don't need a reasonable accommodation during the job application and interview process, then it's no need to disclose. They can wait if they want to voluntarily disclose. They can voluntarily disclose after they receive a job offer and start the job. But I generally tell people if they do not need a reasonable accommodation during the job application and interview process, then no, I recommend waiting.
And then if they don't feel as though they need an accommodation, let's say someone's been seizure-free for 5 years, they may not need to disclose it at any point.
Exactly.
Is that correct?
Okay. Yeah, exactly. If they don't feel that they need an accommodation to do their job, it's no need to disclose, in my opinion. It could, in some instances, it creates more problems than necessary. So if they don't need a reasonable accommodation, then it's no need.
Okay. Thank you. So we do have another question here, and this person is asking, when a person voluntarily discloses epilepsy, can the employer request written documentation of having been diagnosed?
No, I would say I wouldn't understand what the need for that is. So unless there is a problem with the person's job performance and the employer feels that, the person's health condition could be a contributing factor, then there's no need for the employer to make what's called a medical inquiry, because that's classified as a medical inquiry or disability-related inquiry, and those should only be done by the employer. I believe the criteria is with EEOC that they must be job-related and consistent with business necessity. So if the person is not having any issues or they haven't requested a reasonable accommodation that would substantiate a doctor's note, or there not any safety issues, then I'm not sure why an employer would need that. Mm-hmm. But of course, if a person requests a reasonable accommodation, an employer does have a right to receive medical documentation only about epilepsy, not about the person's whole medical history, but related to epilepsy to support or substantiate the need for the reasonable accommodation.
Do we have any other questions for Cherie? Again, just a reminder to everyone that this has been recorded, and what we'll do probably by the end of today is we'll post it on our website so that you can share the link with others, or you can listen to it again. And we thank you, Cherie, for your time and for this very valuable information. Thank you.
Thank you all for having me. And on the slide, I've noted my contact information. If you have any further questions, please feel free to reach out to the Legal Defense Fund, and I will get a response to you either by email or I will give you a return phone call. So thank you so much, Monica, for inviting me, and I hope this information has empowered people.